Okay, this will be a short finish up on that one, and then I may go into another chapter now, but starting number 2. This difficulty, therefore, however great it may appear at first view, will shrink to nothing upon nearer approach, and be rather advantageous than of any disservice by imprinting a clear and distinctive notion of the nature of these several remedies. And such as it is, arises principally from the excellence of our English laws, which adapt the redress exactly to the circumstances of the injury, and do not furnish one and the same action for different wrongs, which are impossible to be brought within one and the same description, whereby every man knows that dissatisfaction he is entitled to expect from the courts of justice, and as little as possible is left in the breast of the judges, whom the law appoints to administer and not just prescribe the remedy. Now that sounds to me like they're saying you can't have more than one thing on. So if you're getting charged by multiple statutes, I don't think they can do that. I'm reading into this. I don't know, but I'm going to come back to this stuff myself. I'm still reading it over and over, trying to decide what it says. And if I may venture to affirm that there is hardly a possible injury that can be offered either to a person or property or other for which the party injured may not find remedial writ conceived in such terms which are properly adapted to his own particular grievance. And that would go back to the quo warranto. Show me your franchise, brother, that you can bring this. If you can't show me a franchise, you can't bring a case against me. In the several personal actions which have curiously explained as debt, trespass, detinue, action of the case, and the like, it is easy to observe how plain, precipitous, and simply the remedy is, as chalked out by our ancient common law. So, in several personal actions which we have curiously explained as debt, trespass, detinue, action on the case, and the like, it is easy to observe how plain, precipitous, and simple the remedy is, as chalked out by the ancient common law. And I think what he's saying is, ask him for his frickin' franchise. Show me that I gave you a franchise, brother. Show me the paperwork from the king that gave you a franchise for me. In real actions for recovery of landed and other permanent property, as the right is more intricate, the feudal or rather Norman remedy of real actions is somewhat more complex and difficult and attended with some delays. And since in order to obviate those difficulties and retrench those delays, we have permitted the rights of real property to be drawn into question in mixed or personal suits, we are, it must be owned, obliged to have recourse to such arbitrary fictions and expedients, that unless we had developed the principles and traced out their progress in history, our present system of remedial jurisprudence in respect to landed property would appear the most intricate and unnatural that ever was adopted by a free and enlightened people. No doubt. They're telling you it's confusing on their side. But this intricacy of our legal process will be found, when attentively considered, to be one of those troublesome but not dangerous evils which have their root in the frame of our Constitution, and which therefore can never be cured without hazard of everything that is dear to us. In absolute governments, where new arrangements of property and gradual change of manners have destroyed the original ideas on which the laws were devised and established, the prince by his edict may promulgate a new code, more suited to the present emergencies. But when laws are to be framed by popular assemblies, even of representative kind, it is too Herculean of a task to begin the work of legislating afresh and exact new systems for discordant opinions of more than 500 counselors. So that's saying that the prince, it's easier for the prince to do one law that covers him than it is for the legislature to do a law that covers everybody. You're really just worried about the laws that cover you. A single legislature or an enterprising sovereign may at any time form a concise, perhaps uniform plan of justice, and evil betide the presumptuous subject who questions its wisdom or utility, but who, that is acquainted with the difficulty of new modeling any branch of our statute law, though relating to but to the roads or to parish settlements, will conceive it even feasible to alter any fundamental points of common law with the appendages and consequences that set up another rule in its stead. When therefore by gradual influence of foreign trade, domestic tranquility, the spirit of our military tenures began to decay and the length the whole structure was removed, the judges quickly perceived the forms of delay of the old feudal actions, guarded with their several outworks of assigns, vouchers, aid prayers, hundred other formidable entrenchments, were ill-suited to the more simple and commercial mode of property which succeeded the former, and required a more speedy decision of right to facilitate exchange and alienation. Yet they wisely avoided soliciting any great legislative revolution in the old established forms, which might have been productive of conveyances more numerous and extensive than the most penetrating genius could foresee, but left them as they were, to languish in obscurity and oblivion, and endeavor by a series of minute contrivances to accommodate such personal actions as were then in use, to all those useful purposes of remedial justice, and were, though the dread of innovation, they hesitated at going as so far as perhaps their good sense would have proclamated them. They left an opening for the more liberal and enterprising judge, who have sat in our courts of equity, to show them the error by supplying the omission of the courts of law. So, if they've done something in equity, and there's an error, and it doesn't follow the law, then the equity's coming back. Equity must follow the law. First, it has to be lawful, then there can be equity. It's not the other way around. And since the new expedients have been refined by the practice of more than a century, well, now 500 years, and are 1700s, 400 years, the purpose of doing speedy and substantial justice much better than could now be affected by the great fundamental alterations. The only difficulty that attends them arises from their fictions and circuities. But when once we had discovered the proper clue, the labyrinth is easily pervaded. We've got to find the clue. We inherited an old Gothic castle erected in the days of chivalry, but fitted up for a modern inhabitant. The moated ramparts, the embattled, yada yada yada, whatever that means. In this part of our disquisitions, I, however, thought it my duty to unfold, for as intelligibly as I could, the nature of these real actions, as well as personal remedies. And this is not only because they are still in force, still the law of the land, though obsolete and disused. They may perhaps in their turn be hereafter, with some necessary corrections, called out again into the common law. But also because, as sensible writer has well observed, whoever considers how great a coherence there is between the several parts of the law, and how much the reasons of one case opens and depends on another, I presume to be far from thinking any of the old learned useless will so much conduce to the perfect understanding of the modern. And besides, I should have gone in great injustice to the founder of the legal constitution if I had led the student to imagine that the remedial instruments of our law were originally contrived in so complicated a form as we now present them to his view. Had I, for instance, entirely passed over the direct and obvious remedies by assize and writs of entry, and only laid before the modern method of prosecuting a writ of ejectment. So he's saying that the direct and obvious remedies by assizes and writs of entry, there's something to go study. He's saying that they're the obvious remedies. And then there's modern things on top of it, like a writ of ejectment. But there's an obvious way to do it. I'm going to have to go look at those myself to understand them more fully. And that'll be coming up. Okay, well, that's the first one of who knows how many. I know I talked kind of fast. I was trying to get it an hour. I didn't know it was 19 pages long, so I can't read 19 pages in an hour. So I'm going to have to break them up into smaller pieces. Um, it gets a little more easy to understand as we go into the next one. Again, I'm just going to be going through the things in Blackstone and pointing out things that Koch said along the way. Have the next one out shortly. See ya.